My dear friends, my colleagues in legal profession, my friends in civil society, and my fellow citizens, good afternoon to you all. Today, I would like to share my views on the recent controversy with regard to national song Vande Mataram under the head Vande Mataram Executive Overreach and the Secular Constitution. The recent directive of Ministry of Home Affairs dated January 28, 2026 reportedly mandating the playing of all 6 stanzas of Vande Mataram at official functions with compulsory standing and attention has revived the constitutional concerns that were consciously addressed at the founding of the Republic. The question is not whether Vande Mataram deserves respect. Its role in India's freedom struggle is unquestionable. The real question is whether executive can expand symbolic civic obligations in a manner that unsettles a carefully negotiated constitutional balance. Public commentary has pointed out 3 central concerns: the distinction between national anthem and national song, the secular compromise of the Constituent Assembly, the constitutional limits of compelled symbolic conformity. These deserves structured examination. My friends, the Constituent Assembly of India debated the status of Vande Mataram in depth. Members acknowledged its inspirational role during the freedom movement, but concerns were raised about theological imagery in the later stanzas, drawn from Anandamath by Bankim Chandra Chattopadhyaya. The resolution adopted was announced. Janagana Mana, composed by Rabindranath Tagore, was adopted as national anthem. Only the first stanzas of Vande Mataram were accorded official recognition as a national song. The national song was not constitutionally equated with national anthem. This was not a rejection of heritage. It was an affirmation of secular inclusivity. To now mandate all 6 stanzas risks disregarding that founding compromise. My friends, Article 51A, subclause A of the Indian Constitution makes it a duty to respect the Constitution, the national flag, and the national anthem. The Vande Mataram song is absent. This omission is legally significant. The Constitution expressly identifies which symbols attract enforceable civic respect. An executive directive that effectively elevates the Vande Mataram song to the same place as the national anthem raises the question of constitutional competence. Executive power under Article 73 and 162 cannot enlarge constitutional duties. Then, my friends, compelled expression and freedom of conscience. In Bijoy Emmanuel versus State of Kerala, the Honorable Supreme Court of India, in its historic judgment in July 1985, protected the students who declined to sing national anthem on the grounds of conscience. The court emphasized respectful silence is constitutionally sufficient. Compulsion violates freedom of conscience under Article 25. Patriotism cannot be reduced to ritual compliance. If constitutional protection extends even to the national anthem, which is expressly mentioned in Article 51A, subclause A, then compelling participation in a national song containing devotional imagery must withstand even stricter scrutiny. Then secularism and basic structure. My friends, in Keshavananda Bharati versus State of Kerala, the Supreme Court held that certain constitutional features, including secularism, form part of the basic structure of the Indian Constitution. Indian secularism requires that state not privilege one religious cultural imagery over others in civic spaces. The later stanzas of Vande Mataram invoke goddess imagery rooted in Hindu devotional tradition. For many citizens, this may be culturally symbolic. For others, it may carry theological implications. The Constituent Assembly recognized this plurality and crafted a compromise. Mandating all 6 stanzas through executive direction may be perceived as unsettling secular neutrality and imposing majoritarian symbolism in official civic space. My friends, in constitutional democracy, symbolic measures are never neutral exercises of power. When cultural expressions associated with the majority are transformed into compulsory civic rituals, the line between national integration and cultural hegemony can blur. A republic does not test loyalty through conformity. It nurtures allegiance through equal citizenship. If state directives produce the perception that patriotism is measured by participation in a specific religious cultural imagery, the risk is not unity but alienation. The strength of India unity lies in voluntary respect, constitutional fidelity, and fraternity across differences. Revisiting sensitive symbolic compromises without wide deliberative consensus risks creating avoidable polarization. In a plural republic, restraint is not weakness, it is constitutional wisdom. So, my friends, the issue before the nation is not the reverence to Vande Mataram song. It is the constitutional propriety of mandating observance in a manner that expands civic obligations beyond constitutional text, implicates freedom of conscience, and potentially unsettles secular balance. A mature democracy resolves such matters through dialogue, legislative clarity, and judicial review, not executive assertion. The true tribute to the nation lies in preserving the constitutional equilibrium crafted by its founders. So, my friends, the government, we hope that the government will not make this controversy still further and complicated. Thank you. Thank you very much.